good afternoon. Thank you for joining us. Today we're talking about slander, libel, and defamation. As we start, my name is Christopher Achkar. I'm the managing partner here at Achkar Law. We've been doing this for just under 10 years, and we have a group of 25 lawyers. About 40% of our work is in corporate commercial disputes, and 60% is in employment law. So this is who we are. Our mission, we really do try to be the go-to folks for people with complex disputes. What is today going to be about? Today is about defamation, about its intersection with reputation, how it affects your financial health, and various other factors that you should take into consideration before you land into such issues and while going through them, if in the unfortunate event that you go through them. So what will you gain from this webinar? We will define everything, we'll clarify everything as much as we can within the 30-minute period. We'll identify how to spot certain issues that we often see in front of us and we don't recognize as potentially injurious. And we'll talk about legal and non-legal ways to resolve these disputes. And by non-legal ways, I don't mean illegal, knowing somebody who knows somebody. I just mean pre-litigation ways of resolving these disputes. And also full-term ways of, or long-term ways of resolving issues and spotting them before they happen. Defamation first is a big category of what people colloquially refer to every day as speaking ill of someone. Defamation is divided into two different broad categories, one being libel, and this is defamatory statements being done in writing, whether they're articles online, whether they're blog posts, whether they are articles published in newspapers or online reviews. And the second one is slander. And with slander, it is essentially the same meaning, except for the only difference is instead of it being in writing, it is done verbally. So it could be between people, it could be in a public setting, it could be in a private setting. And often slander leads to libel as well if something that is verbal gets published. Legal implications for businesses when these issues happen are fairly serious because businesses rely on revenue, on their income that they derive from clientele and from their customers. So if someone was to go and defame a business, whether it's in writing or verbally, that means saying something that they know is untrue for the purpose of hurting someone financially mainly or for any other intended harm that could be categorized as defamatory statements. For those to happen, the effect has to happen, but the business will also have to, it's not just for a business to say, well, we lost income or customers because someone posted a negative review. They have to actually prove it, and it could be easily proved, but they also don't have to prove it in many ways. And the harm itself, which we will get into about how to quantify the harm and the damages, those can be done in a creative way that captures a lot of the time that one would have to put in to get themselves out of the mess that defamation put them into. So as we said, recognizing these defamation threats is simply by, you could just spot them online, whether it's social media, the comments, the mentions that someone makes. So often businesses get actually tagged in defamatory statements or comments that happen in certain posts or comments that happen on their individual pages. There is, as much as there's the freedom of speech, a theme that is important, it is important for people to be honest in their reviews and not set out to destroy or harm a business. As much as these things don't always happen overtly, they do happen covertly also between competitors. So whether it's social media or a public setting, industry platforms also, like the chambers of commerce or other industries where people sort of could talk between each other and then spread negative rumors that take effect beyond just that small group itself. How to monitor these issues and essentially defamatory statements. This is the non-legal solutions that I was mentioning. You can set up services like Hootsuite and Google Alerts, and you can set parameters about what it is that you'd like them to alert you when it comes to what comes out. So you'll get these notifications, but like I said, often the social media platforms themselves or your neighbors will tell you they read something if that's the case. As long as you're diligent and you don't turn the blind eye to what could be happening, then odds are you will see what is being said about you, and often people do. Impacting the business. It is not just losing clients or customers because of defamatory comments, which is essentially the financial harm in there. A reputational harm, even if it's hard to quantify, it is to be calculated one way or another for a judge. And even operational risks and operational expenses are part of what you add to a potential defamation lawsuit. So when calculating damages, one has to document everything, and we'll get into it in a bit about documenting everything that happens, including time spent on resolving issues. That is important, and potential business lost from you having to respond to this. These are all certainly issues that are worth bringing up. Same with spotting defamation, social media review sites. As long as you keep your eyes, that's the first step. You keep your eyes and your ears open and you spot them. So that's all I'd like to talk about when it comes to spotting. Now, how to identify the important documents here. Everything that you think may be relevant is probably relevant. So screenshots are important. Links to something that exists is important, but it's also important to take a screenshot of a link that is live now, but is potentially not going to be live later. Even memos from someone who has seen information or who has heard information. A memo meaning just a document that is signed saying, this is what I was told, or this is what I heard. This is better than nothing. It helps with putting context and flavor to the case and adds to why really the harm should be quantified such. So it is important to preserve the information you have, and it's important to tell the other side to preserve all the documents that they have, and they are required to preserve it under the Evidence Act. As long as you do tell them about it, then their obligation is a lot more clear. So make sure you do when it happens. But document and date everything that you document. That will be important. Dating a document or when you receive something will be even more important later when it comes to libel in itself. The notice of libel that is sent out, that has to be sent out within a certain period. We'll get to it shortly. Assessing the impact, like I said, financial loss. So if you lose a client, and if a client tells you, I was going to hire you, but because of this that I saw, I have questions about your services now, and I'm not sure I want to hire you. And you know what? I don't even want to hear your explanation about it. I will not be hiring you anymore. Then it is quite easy to point to the loss, and one must point to causation because this is a tort. So this is like personal injury case. So you have to prove causation from one to the other, and it is quite easy there to show that it happened. Reputational harm, same thing with if you were to stop being invited to business events or social events from colleagues because a certain colleague said something about you when they were drunk one day, then that is something that one can try to recuperate. It's hard to quantify reputational harm sometimes, but other times it is easy. So if you lose your job because of it, it's quite easy to know what you lost and for what period. but these are things that one has to keep in mind and must document at all times. Operational disruptions are also extremely important. So if you have an accounting firm and every day, you are running X number of transactions, but over a certain week or month or year, you've had to cut down on how much you can do because you've had to address other things. That is operational disruption that can be calculated and strengthens your case when you want to prove that something took that much effort out of you to correct as opposed to it being incorrect to begin with. Responding to defamatory comments, negative reviews, though negative reviews don't have to always be defamatory, keep that in mind. Sometimes a negative review is an honest review, and sometimes a service is in fact inadequate. But one would have to say that as opposed to make up stories and essentially lie about things that did not happen to exaggerate what may have been in disagreement, the latter is less allowed or punishable at least. And the earlier one is fair to do, and it is everyone's prerogative to voice their concerns. One way to deal with this is, and I always recommend this, I'm a big fan of this. I think one can't and shouldn't hide or try to hide, and one should address what happens as honestly as possible and as fast as possible. That's the only way to be, I think, authentic and true and succeed. Odds are, if you're here and you have a business that you're running, you probably feel the same way. You see something unfair, you want to address it, you want to be careful about how you address it, you want to demonstrate professionalism, understanding, empathy, as much as you could disagree with an unreasonable comment that you've received. If it is a review, rather, if it is something like a blog, this is more orchestrated than just a review. So a blog or a page online being posted or an article in the Toronto Star, those are concerted efforts that would be punishable more than one would think an average review. But even then, if the effects of the review are the same as that of a blog, and especially if the readership of Google is higher than that of your blog, then maybe a comment can in fact be more harmful. But all that said, when those happen, responding to them publicly and showing that you actually care about your reputation and you're addressing things as much as you can is important. Doing so also privately is important. Sometimes not addressing things privately will give the sense to the individual person that you just don't care, and that potentially could just fuel their efforts to keep going. But also sometimes engaging could fuel their efforts. So you have to be mindful of who you're dealing with, obviously on the other side. It is worth, if you think you're out of your depth when it comes to crafting the right language, when it comes to responding, when you think you need to respond, it might be worth hiring a PR professional. They can be quite pricey, but they don't also need to be. They aren't all pricey. And the last point of this slide, stay calm and factual. It can be emotional. It is emotional. You built something from the ground up sometimes, or you work somewhere, or you work hard on developing a relationship, and for someone to just come in out of nowhere and without any real reason or any factual reasons at least ruin your reputation. The next step is decide whether to pursue legal action. And that is important. Whether is important. You may not, I see the slides have changed. Originally they were decide whether to pursue. And I mean that, and in the name of authenticity, I just said what the original slides are. Speaking with a lawyer or seeking legal advice is not always necessarily beneficial, but it's not harmful. If you feel like you may be losing something or your business is in disrepute, then you may want to. The whether to pursue legal action could be a decision that you make game time. If you see that these blog posts have stopped showing up and the comments have disappeared or the reviews were down and the person has forgotten about you, then you may not want to still pursue something that may throw more fuel on the fire. But if it is something that is happening and it is out of your hands and you can't really control it as much, then sometimes, in fact, you may have to do something sometimes, and that is known as mitigating your damages. If you allow something to accumulate there and to accumulate a bad reputation for you and to keep harming your business without you actually trying to mitigate it, then a judge may find that you didn't, in fact, try to minimize it yourself and wouldn't be as kind with you if you're not proactive. And this segues beautifully into our next slide, which is libel notices, when they are needed, are exactly for the point of mitigating your damages. If you allow for a comment to stick around, and you could have simply deleted it, or you could have taken action one way or another, then this would be considered as you have contributed to the damage yourself that you faced. A way to stop that is when you notice certain issues coming to light, if you notice something that happened, then you have to, especially in writing, then you have to issue a libel notice before your claim is allowed to succeed. A libel notice is the court's way to avoid having to do essentially work on your matter, which is fair, and that is good. This is a way to discourage litigation, so it's good. This notice is required from someone who notices a comment or an article or something being made about them and having to notify the other side of having to remove it and the reputational harm and financial harm that it's causing within 6 weeks of noticing it. If you notice it, the most important thing is to actually do it immediately. You shouldn't wait any prescribed time to actually send out a notice. You should do it as soon as you notice it, and that helps also with mitigating your damages when it comes to calculating what should be owed to you. What should be in a libel notice? It should be an honest and true attempt at having a resolution. That means a retraction. It means if an apology will do, then an apology will do. If it means a nominal amount, even though you know your damages are more, but you also know that with the nominal amount, you'll get an agreement on the other side that no more posts will be ever made, and even existing posts will be removed. It's not just about the financial aspects of something, it's also the peace of mind that you get after having this resolved and potentially not show up again. So giving an opportunity to retract this, which is essentially the equivalent of a mediation, so to speak, this is extremely important to show a judge that you've made an honest attempt at resolution. The preserving rights to sue is what I had mentioned earlier, when you ask the other side to make sure that they keep all documentations in their possession without destroying them. Same with preserving the right to sue, so having a notice issued and having it retracted potentially, that doesn't remove the fact that sometimes harm has already been done. Sure, it might mean that harm will stop getting done after it's being removed, but it doesn't mean that it never happened. Preserving your right to sue allows you to sue on a certain matter beyond a certain prescribed period because you've done your due diligence and you let the other side know to remove what they need to remove, otherwise consequences will be coming. That is a second important part that is in a libel notice. Proof of harm is extremely important. The reason that the proof of harm is important is from a sort of persuasion perspective. If you demonstrate to someone that their actions are actually harming you and they're actually making you lose money and you show them how, they may know that you're not bluffing and you're not joking about it and you are serious. So the more of an honest attempt you make at showing proof of harm, this does get the other side to potentially get their backs down and not against the wall and potentially having a resolution earlier to any issues you guys have. There are lots of defenses to defamation. We mentioned here three of them, but there are a few other ones. Truth is one of them. So if you are saying the truth, then you are, in theory, allowed to say whatever you want. There is interesting case law that even truth, but going out of your way to say certain things with the intention of harm may play a factor in still finding that there was injurious intent happening there. So while it might not end up being defamation, there is still actual financial harm that was caused by a defendant to a plaintiff. So could still be fair. But truth often is the most used defense in a defamation case. But often, obviously, what is truth and what isn't, that is often subject to interpretation of these court proceedings. Privilege is a good one. Privilege is anything that is in a privileged setting. So that could be you and your lawyer. That could be, there are professional obligations for medical associations that are different than privilege, but anything disclosed in one case, for example, can't be used in another case. Parliamentary settings allow for this type of privilege, and this is to allow one party to potentially criticize another party and to do so freely, and that is for the purpose of the greater good of democracy. A public hearing, as much as, even though it's public, not having the comments there be used against those who make them, especially in parliamentary settings. So that is important. Fair comment is an honest opinion on a public interest issue. And often many people try to use that, saying, I'm going to say the pizza from the restaurant down the street is terrible, even though it's not, and it was cold, even though it wasn't, and there was insects on it, even though there weren't. Those you can't say it was my honest opinion. I thought this was that, when the threshold isn't as high as one thinks. How to protect your business: you maintain every record you can, just document as much as you can, save, screenshot, and having them in different places. So whether it's a USB key or printing them out is also helpful. And I think we are out of time. If you have questions, please reach out. Thank you so much for attending again. Bye-bye.